To the best of my knowledge, Simon is the only Canadian on the Plan Commission. So we are now an international body. So welcome. We're glad to have you both with us. You have the agenda. Are there any additions or corrections that need to be made to the agenda? If not, it will stand approved as presented. You have the minutes of April 8th. Are there any additions or corrections to the minutes? On page 4, the section, the discussion of modifications to administrative rules, I think staff wisely compressed these minutes and included only the principal points of discussion rather than everything that was said. I think the minutes should note that we did make 2 amendments to the Rules Committee draft, one in Article 4, Section C, and one in Article 9, and the staff has those changes. I think the minute should also note that the adoption was done by roll call, and the roll call was unanimous. With those corrections, is there a motion to approve the minutes as corrected?
So move.
Goddard, seconded. Lewis. All in favor? Aye. Opposed? Hearing none, the minutes are approved. What? Okay. The next order of business, a zoning ordinance text amendment. Case number 15 PLND 0027, an amendment for the establishment of a definition and land use regulations for firearm ranges. This is brought to us on, is it aldermanic reference? Is it council reference? Is it staff? Okay, by staff. Staff are the petitioners in this case. This is a formally called public hearing. I don't know if the public is going to want to testify on this, but she's certainly welcome to do it when we get to that point. Okay. We will proceed as usual in hearings. Staff will present their analysis and recommendation. We will then entertain questions for staff, including questions from the public. Public will then be invited to make any comments, statements that they wish to make, and we will cross-examine them. There being no further questions, we will then close the public record and proceed to deliberation by the Commission. This is, on this matter, we are a recommending body. The final action will be taken by City Council. So with that, Demir.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. So the only case tonight on the agenda is a text amendment that deals with firearm ranges. This is to introduce land use definition in the zoning ordinance and then introduce land use regulations for that. So this is a follow-up ordinance to Ordinance 6-0-15, the weapons code of the city code that was adopted in March of this year. And the weapons code dealt with, it's basically a reaction to a state's firearm or concealed carry act that was adopted in 2013, and that regulates licensing, possession, and registration of firearms. What it does not license and regulate is the location where one can purchase a firearm and these facilities where one can train using firearms. So the Ordinance 6-0-15 does deal with the firearm ranges and where one can purchase some firearms, the discharges of firearms, and various other regulations regarding the weapons and handguns. So there was, because the weapons code introduced firearm ranges as an allowable use in the city, we needed to make a change to the zoning ordinance that also allows firearm ranges as one of the allowable uses within certain districts. So we needed to do a text amendment that is consistent with the weapons code. And in essence, it's exactly the same. We are introducing a definition that's exactly the same as the definition in the original ordinance, the weapons code, and that's that a firearms range is any establishment where the discharging of a firearm, as defined in section 981, which is the weapons code, is allowed for a sporting event or for practice, instruction, testing, or training in the use of a firearm. The firearm range may also include rental of a firearm for allowable uses within the establishment and the firearm dealer as defined and regulated by Title IX, Chapter 9, the Weapons Code of the city. So that's the definition. It's, like I said, it's exactly the same as it is in the Weapons Code. It did not make any sense to introduce a separate definition or any other restrictions. So the proposed regulations are also exactly the same. Currently, we do not allow any type of firearm range, and the proposal is to allow them within the I-1, I-2, and I-3, the industrial districts, as a special use, but only if it is more than 350 feet from an existing school, child daycare facility, or a public park. And this is something that has been discussed extensively at the Planning and Development Committee of the City Council, and also at the City Council when this was adopted early this year. So a different number of these distance separations from schools were proposed, and ultimately what the City Council felt was that the 350-foot separation from these uses is the most appropriate distance separation for firearm ranges, and that's why the Weapons Code includes that separation requirement. This map shows the theoretical areas of the city where a firearm range could be established. There was some discussion before the meeting that the map indicates these pink areas that meet the distance separation requirement, but most of these lots are actually closer to the residential areas and schools and parks. So in reality, the entire property has to be within the 350-foot separation, and therefore there's not a lot of properties in the city that would currently, as they stand today, that would qualify. Of course, that means that one can purchase certain lots in these areas, do a re-subdivision or combine multiple lots, and so that the entire facility, the entire lot, is 350 feet from schools and parks, et cetera. So in essence, that's the proposal. There's no other changes to the zoning ordinance or to the weapons code for that matter. In regards to the standards, there are 4 standards for the text amendment, as for any other ones. We believe that all standards have been satisfied, and in particular the first one, whether the proposed amendment is consistent with the goals and objectives of the comprehensive plan. We believe that this is satisfied. This is another use that would be permitted in the city, and this proposed text amendment makes the zoning ordinance consistent with other portions of the city code. We also believe that the proposed amendment is compatible with the overall character of the existing development in the immediate vicinity. That's why the proposed use was selected to be only in the industrial areas. And we do not believe that these types of facilities or the proposed amendment will have adverse effects on the values of adjacent properties. This, again, is something that would be evaluated as part of the special use review process if there was a proposal to review. And then at the same time, standard number 4, which we believe is not applicable in this case, but if a proposed facility is considered, we would make sure that there's adequate public facilities and services servicing that property. So with that, staff recommends approval of the proposed text amendment, and I would be happy to answer any questions.
Questions for staff? Commissioner Isaac.
What are the parking requirements going to be for a firearms range?
Good question. We would have to investigate that. I don't have that off the top of my head. There is no land use definition within the parking requirements for the firearm range. We're not proposing to add one. So we would probably find something that's the most similar to that, depending on how the facility is designed and what it serves. Oftentimes, for these uses that are special uses, we ask for traffic studies that indicate when the maximum capacity will be, and evaluate the existing parking scenarios on the site. So because these things are relatively uncommon and they can vary based on scale and I guess how many ranges they have, that's something that will have to be determined probably on a case-by-case basis.
Understood. Thank you.
The special use standards include reference to traffic impact, but not parking, don't they?
I believe one of the standards talks about negative impact, and certainly if a facility did not have adequate parking based on their proposed use and maximum capacity at certain times, a spillover parking onto the existing streets or surrounding properties would be a negative
Okay,
effect.
so
we
that's
would-
how you would get at it?
Yes,
Is under the
correct.
special use requirements?
Correct.
Okay, Commissioner Goddard.
What's the justification for only 350 feet separation?
That's a good question. We had that conversation before the meeting, maybe the counselor can provide a little bit more information on that. I believe when this was presented to the city council, they investigated various distance separation requirements. I think they initially started with something less than that, but felt that too many properties would be eligible for this type of use. And then they wanted to go with a 500-foot separation, which then essentially eliminated all properties, and that would be a violation of the constitutional rights. So I think the council felt that a fine medium of 350 feet that allows only a few properties to be eligible, they felt that that was an appropriate distance and amount of properties eligible.
Commissioner Lewis, yeah.
So can you clarify, the 350 feet came from the the weapons ordinance that was passed by the city council? Is
That is correct. I have it pulled up here. This is the ordinance that amended the Title IX, Chapter 8, and so the whole ordinance had, its own definition section that talks about different items, ammunition, handguns, assault weapons, et cetera, and it also has a definition for, let's see. So this is the section that deals with firearm dealers that are permitted only at the firearm ranges. And it talks about where it's allowed, allows for rentals, sale, specifically at these facilities, and they have to be 350 feet from R1, 2, and 3. And as I mentioned, the weapons code talked about various other things, discharging of firearms, general exemptions, some fees, et cetera. And because a firearm range is allowed in those specific districts within this code, we needed to do an amendment to the zoning ordinance that also lists it as an allowable use within the I1, 2, and 3.
Can I get a little bit of a clarification as to what the reality is of what properties could be by maybe zooming in on some of those specific areas that are,
Yeah.
that you talked about the whole properties having to be outside of the area?
You'd have to have a parcel map, wouldn't you?
Well, this is a parcel map, yes.
Oh.
From what I can see, I can only see 2 properties in the entire city.
And that's what I was trying to allude to, that as it stands right now, sorry.
So starting with the one that's up where the Volkswagen dealership keeps their cars, whatever that is.
On Oakton.
Yeah, no, I was going to say up north off of Emerson. But you can start anything you want to.
So, for example, so these little lines, the black lines, indicate existing parcels, okay? So this particular property is not fully pink, which means that there are portions of this property that are less than 350 feet from schools, parks, or whatever, and therefore this particular property right now is not eligible to be a firearm range.
Unless it's subdivided.
Unless somebody somehow subdivides it that a new property on this lot is fully outside of that 350-foot range.
But the pink, if the pink were a single parcel, it would meet the requirements.
Correct.
Every side of the pink space is 350 feet from a sensitive use.
Correct.
Okay.
So I think if we go down
All
to
right.
Greenleaf and Dodge, we'll see a couple of properties that actually comply.
That's correct. So these properties, this property looks like it's probably exactly 350 feet from any schools, parks, et cetera. There are some small lots here that are eligible, so one can potentially combine these lots right here into one larger lot, or maybe take portions of this lot or even this much larger lot. So this is an area that certainly could have a firearm range. And then further down south on the north and south sides of Oakton, definitely this property right here that looks like it's landlocked off of Oakton, but it's a parcel that is fully outside of the 350-foot range, and there looks like there's a couple right there on the north side of Oakton too. There are no proposals right now for any kind of a firearm range in the city.
Okay. More questions, further questions? Jessica, do you have a question?
Probably, but I probably should just be quiet.
You don't have to promise. If you got a question, ask it.
I guess I can't understand why we're, quote, inviting, if it's silent on ranges, does that mean that they can come anyway? If we don't have something that allows them to come with these restrictions,
And I think that's where the concern was from our legal staff, that it became unconstitutional and a violation of the,
not have a firearm range. I know it's unconstitutional not to have a firearm, but a
But-
range?
If I can interject really
I don't-
quickly.
Yeah,
please,
please,
Counselor.
Mario.
Yeah, so Mario Tretto, Assistant City Attorney.
Oh,
No, that's good.
No, this is a good question. Legal staff did our due diligence in looking at case law, and in particular with City of Chicago. I think when we were talking about the revisions of the 250 feet versus, I think there was a proposal for 500 at City Council, that was so restrictive, and the case law would indicate that you needed to make it so that you would have this ability to have a firearm range in your municipality. So it's based on case law. Like we did our research, and
That we have to be able to have a firearm range in our community? Is that what case law says?
based on the preliminary firearm review, I mean, I can do a little bit more research if you'd like. But as I recall, when we had a 500-foot suggestion at the city council level, that was deemed to be too expansive, where it would just not allow for it in the city.
I still don't understand. I understand the Second Amendment. I understand that we can have firearms. I don't know that anywhere that it says constitutionally we have to have firearms ranges for those firearms constitutionally.
Or if I can add to that, or whether we have to facilitate people
Acquiring
acquiring
firearms to take them to the range.
So a gun shop is a means of facilitating, allowing them to acquire weapons. It says you can have them, but we don't have to facilitate.
Say, come here and buy it.
And we
Come here and
if I
practice
may
on
say,
it.
we don't have to. But I think what Mario is trying to say is that based on the research that we've done, the city's opening ourselves to lawsuits, potential lawsuits from these types of uses that are looking to locate. And we just the city council felt it's appropriate to just have some regulation and introduce it in certain areas.
And we've done very thorough research that we have to have, that we have to be able to have a firearms range.
Well, and then the additional concern that we also had with being able to do the licensing and the building restrictions, that would give the city some sort of control with a lot of the issues that we have, such as noise, sound pollution, dangers that the firearm ranges can prevent. So we just wanted to make sure that the city had some ability to look at any of those issues that might arise, and may have the required background checks that you need to with all of that.
Am I correct here from a procedural standpoint that even if we were to reject this proposal, the ordinance which makes firearm ranges a permissible use in Evanston would stand.
I guess I don't understand how that got in either, but
Well,
Well, and
what I'm saying is that City Council has preempted the question of whether firearm ranges are permissible in the city of Evanston and has left it to us to adopt the definition of those.
nobody asked the question I asked at City Council, I gather.
So the issue,
Prepared to believe that.
the issue has, and it's an additional, that's something else that to consider is the fact that this was brought up at City Council, and so the 250-foot definition that is permissive of the firearm ranges, that was addressed at that level. If there's any modification to the 350 feet, then that would require an additional modification to the actual weapons ordinance that City Council has already accepted and approved.
Am I allowed one snarky question? Did nobody at City Council raise the question that I raised?
I wasn't present at that City Council meeting. Sorry.
That's a fair question, Jessica. Commissioner Isaac.
Jessica, I believe it's a matter of preempting a user occupant who would want to operate a firearms range here in the city. If the city hadn't taken the steps to regulate it ahead of time, they could have gone to court, and ultimately, if they prevailed, would have ended up potentially being able to put a firearms range somewhere where the city wouldn't have wanted it. And so this way, the city is able to take control. They are proactive as opposed to reactive, and ultimately get to put the firearm ranges where they want and able to regulate them in many ways.
Some number of years ago, Lake County went through a similar fight over adult bookstores, and it was another case where it was clear that they were not going to be able to prohibit them entirely, so you needed to manage where they were going to come. That was a beastly fight.
There's definitely a line of cases dealing with, I believe it's multifamily housing, that cities were trying to prohibit multifamilies from inside their borders. Some of our neighbors to the north deal with those kinds of issues, and I think that what the city is doing here with firearms ranges follows that same line of cases.
Commissioner Belisle.
Me to add on to what Demir was saying in his presentation earlier, is that by talking about the difference between the 500-foot distance that was deemed too restrictive, is that the city, I believe, is not allowed to use zoning as a way to effectively ban a usage. That doesn't mean we're encouraging it. It just means that it is technically allowed. And I think that needs to be made clear.
Thank you. Commissioner Lewis.
So I kind of want to know, it's not clear to me exactly what we're adding, the value we're adding to this weapons ordinance. And if staff can please clarify, what we've done is simply add the industrial zoning to this as a special use. Is that the only thing that wasn't covered that restricts it? I mean, it could have been in a commercial district, according to for example, or some other district, certainly not a residential, but according to the weapons ordinance. And is that what we're adding?
That is exactly right. Right now, the zoning ordinance does not regulate, does not address firearm ranges. They're not defined, they're not allowed anywhere, one way or the other, permitted or special use. However, there's a separate chapter of a city code, the weapons ordinance, that allows firearm ranges, defines them, and regulates them with this distance separation, and says that they are allowed as special use in the I-1, 2, and 3. So what we have is a discrepancy between the two ordinances, and there's a need to change the zoning ordinance so that it's consistent with the weapons ordinance. So all we're doing is basically adding a new use to the list of special uses in the I, 1, 2, and 3.
Okay, but
we're not adding-
all the terms have been decided
Exactly.
by the ordinance.
We're not
right?
adding any new
We're not
words.
adding anything, we're just
Correct.
rubber stamping this, basically,
Yes,
and
correct.
saying.
We're,
okay.
we're taking
Okay,
words that are already in the ordinance and
Right.
putting them in a new place.
Okay,
Yep.
okay, that's what
I was
wanted to
trying,
know.
I was going to avoid the rubber stamp idea, but yeah,
well, that's-
essentially. Simon?
Thank you, Mr. Chair. I think a question to staff, what other ways could the city use to regulate if there was a proposal for a firearms range within the city, other than what we just are discussing on the zoning part of it? And the building part of it that's also included in the packet.
Well, I mean, ultimately, any use would have to be either a permitted or a special use. I guess alternatively, we could have allowed them as a permitted use, a use that does not have to go through the special use approval process to go to city council for evaluation of the standards. I guess that could have been done. There's an option that the zoning ordinance could add an additional separation requirement above and beyond what the weapons code allows. Certainly anything less than what's in the weapons ordinance does not necessarily make sense, because then the weapons ordinance is more restrictive. So if the zoning ordinance says 400 feet or something like that, then that we can certainly do that, but that was not the intent of the city council to do that, so.
And so if there was such a proposal that in a lot that fits all the zoning needs and the building plans would fit all the building codes, by going to the special use, there'll be another layer where there could be public comment and expression of interest or disinterest in the
As you may expect, these types of uses are a little bit contentious based on their scale, proximity to other sensitive uses, parking concerns. So they certainly warrant a special use review by the Zoning Board of Appeals and the City Council.
Demir, if I could just add, the weapons ordinance also does require it to be a special use at this point, so that would require modification of that ordinance as well if there would be a proposed change of that.
So we asked about parking, how that was regulated. How is noise regulated?
I don't believe there's nothing in the current zoning ordinance. We do have different sections of the building code that deal with the sound abatement within the building, and these facilities. There's a separate section of the building code that deals with the type of insulation that would have to be provided inside the building.
But we restrict what the noise of air conditioners at a property line. We restrict the amount of light spillage that can go off your property. Is there no restriction for this use for how much, sound can be?
Yeah, I think there is.
to that extent?
I think in the building code there is.
In the building?
In the building code,
In the building.
yeah.
I don't know that for the fact, but I know that the building code would address the design of these facilities.
Yes.
Thank you, Mr. Chair. Just a very, very small grammatical issue that I'd like to point out. On page 4, it's section 3 -31-3, there's a space missing in between or and revocation.
But this is the ordinance. This is not.
It's worth pointing out, but I'm not sure we can do anything with it, unless
Okay.
it's our section of the ordinance.
I thought I would point it out, but
Okay, is it our part of the ordinance?
Are we talking about 51015, the ordinance?
correct. Yes.
So that's a new ordinance that's proposed.
Okay.
That's going to have various other changes to the rest of the city code. Part of that are the changes to the zoning ordinance. So yes, that ordinance can certainly be modified.
Okay.
Yeah.
All right, anything else? Well, commissioners, what do you want to do? I guess I will ask if anyone would like to move to approve the staff's recommendation as presented and send it on to council.
So move.
Belisle, second? Oh, come on, people.
Second.
Goddard. We have a motion and a second. You people are difficult.
There's not a lot of enthusiasm.
No, I understand that. All in favor signify by saying aye.
Aye.
Opposed?
No.
4 ayes. Chairman votes aye. 4 ayes, 1 nay. The motion is adopted. The staff's recommendation will be sent on to council. I believe, Demir, is there anything more that needs to come before us under other business?
I do not have anything else.
I guess one thing, just to clarify something that, as Demir and I talked yesterday, was unclear. Last month, when we adopted the new rules and the revised rules and procedures, we agreed to amend Article 13 to take the hearing procedure back to the way we had it before. And what wasn't clear was whether that was simply sort of a ministerial action that the staff could take, or whether we needed to bring that back to the commission as an amendment. I think we need to bring it as an amendment, so I have asked staff to prepare that revision of Article 13. I hope we'll have it by the end of May so that we can bring it back to the June meeting. It shouldn't take long, but I think since we adopted the rules, we need to adopt that as a revision. Is there any public comment this evening? Thank you. Anything else to come before us? If not, may I have a motion to adjourn? Lewis, seconded.
Second?
Goddard, all in favor? Aye. Opposed? Nay. We stand adjourned. Thank you all.